Hello, it's Dr. Michael Arnhem here again with Bernard the Barrister Bear. Say hello, Bernard. Hello. Today we're talking about clinical or medical negligence. Medical negligence. And this is about a shocking case, actually, but it's relevant to lots of other cases. And unfortunately, medical negligence is not as uncommon as we would like it to be. The Royal College of Physicians has estimated that 72,000 deaths are caused every year as a result of what they call doctors and their mistakes. 72,000 a year. And the Royal College of Physicians is one of the top medical institutions. And of course, this is only talking about deaths, not other injuries. And one of the worst aspects of medical negligence is that it's very hard to win a case against a health professional. The odds are stacked against you if you try. Why? It all goes back to a case in 1957 called Bolam against Friern Hospital. Or, as we lawyers like to say, Bolam and Friern Hospital. Mr. Bolam was suffering from depression. Yes, that's all. And he was given shock treatment. That's why this is a shocking case. He was given shock treatment, which can be effective and is still used to some extent. Its official name is electroconvulsive therapy. Electroconvulsive therapy. Now, normally, you are held down on the bed or you're given relaxant drugs to prevent this therapy from causing convulsions which might be seriously injurious to you, because the therapy involves passing an electric current through the body of the patient, which does give him or her convulsions. But if he's given a relaxant drug or is held down on the table, then at least he is unlikely to suffer any ill effects from those convulsions. In Bolam's case, he was not held down on the table. He was not given relaxant drugs, and the result was that when he went into convulsion, he suffered a bilateral fracture of the pelvis. In other words, his hips were broken on both sides, fracture of the hip on both sides. He was in a wheelchair, a pathetic sight when he came to court. You might think this is a cut and dried case. Should obviously have won. What a terrible way to administer this rather barbaric treatment. But the hospital was able to bring to court a number of medical so-called experts, people working in the same field, psychiatrists as well, who could say, we also don't hold the patient down on the bed. We also don't administer relaxant drugs. In other words, we were just as negligent as the people that Mr. Bolam is accusing here. Well, they didn't say that, did they? Well, no, of course, you're right. They didn't say they were being negligent. They just said they didn't adopt those practices. They didn't think it necessary to hold the patient down. They didn't think it necessary to administer relaxant drugs. They also didn't think it necessary to warn the patient of the risks, because that was another thing that Bolam complained of, that he was never warned. And the hospital won the case, because the test, as set out by the judge, it's only a first instance case, it never went further. The test was that as long as there was a responsible body of medical men skilled in that particular art, in that particular branch of medicine, a responsible body of medical men, or women, I suppose, a responsible body who agreed with the defendant, that was good enough. Then the defendant couldn't be negligent. And they found several doctors, psychiatrists, who could say that they also adopted the same rather lax procedure that that particular hospital had adopted. So, as a result, Mr. Bolam lost his case. What is meant by a responsible body of medical? A responsible body doesn't actually refer to any particular institution. It doesn't have to be any particular institution or any particular number of people. As long as you can collect together a few so-called expert witnesses to back your position up, that's good enough. And actually, that still remains the law today. Very largely, there are one or two minor variations, but essentially Bolam still rules. Bolam still rules. In one area it definitely doesn't anymore, and that is to do with warning. That law was changed in 2015, a 2015 case, again another court case, this time went up to the UK Supreme Court, which said there has to be informed consent, and therefore if there are material risks, they have to be disclosed. That, of course, is another question. What is a material risk? But in general, Bolam still rules. More next time. Bye-bye. Bye-bye.